My name is Cletus Fobuziawa. I am a jurist at law and a licensed financial professional based in the United States of America. Talking about succession and inheritance of property by women in Cameroon, I wish to say that many years ago, women in Cameroon, especially in the northwest and the southwest regions of Cameroon, which was then the southern Cameroons, were being treated queerly as a result of the customary traditional practices, to the extent that a woman was considered to be a property of a man. And being a property, traditionally there was no place for a property to be able to inherit a property. Hope you understand what that means with respect to the tradition. And women suffered this because there were cases where when a man died, the wife was supposed to be inherited just like any other property by the next of kin. And in some traditions, sometimes this person who had to inherit was maybe a brother of the deceased or a son of the deceased. And considering that the woman was a property, there were abuses like even giving birth to children with this woman, sometimes unconsensually, because the woman was forced to agree with that, given that it was the tradition at the time. But that tradition has been long abolished by virtue of Section 27 of the Southern Cameroon High Court Law, 1955, which gave room to the regulation of traditional practices, to the effect that traditional practices that were non-repugnant to natural justice, equity, and good conscience were not to be admitted into law. And Zamcho Florence, in a case against Chibikom Pitafro and some others, a landmark case, brought an action which was against her inheritance of a property by, according to the Mancon tradition, because she was an adopted child of the deceased, and more to that, a female. This case was successful by the evocation of Section 27 sub 1 of the Southern Cameroon High Court Law, 1955. Similar facts evidence of this same case were equally evoked against the mutilation of the genitals of the female folks of the Manu community, because the Manu tradition asserted that if the genitals of their children, female children, were mutilated when they were young, by the time they grow up and become women, they will be more faithful to their husbands, whom they believe were to go hustle and will not always be around to fend for their family. And so the marriage should be stable because their women will not have that natural urge for sex like they would have had without the mutilation of their genitals. And so their marriage will be more stable. But some educated folks of the Manu community, within the framework of evolution of international human rights, evoke that aspect of the law and some other instruments of law, and they succeeded in the abolition of the mutilation of the female genital mutilation. Another aspect of traditional customs, which contrastly was rather accepted into law because it didn't pose any harm, was that of sending a pregnant woman or a nursing mother from a matrimonial home before or shortly after pregnancy, because the Bakwere tradition asserted that during that period there was likelihood that the woman's character would have been influenced by the pregnancy, and so the woman may become wayward or naggy. It would be unfair for her to be sent out of the matrimonial home by the man during that time on grounds of her newfound character. So to say that traditional practices that abuse or discriminate against women hold in Cameroon? I would say no, but it does for women who are ignorant of the fact that the law is against such practices as far back as 1955. Thank you.